attended parent-child visits?
Yes, I have.
About how many visits have you attended?
3.
And during those visits, did you make any observations for any concerns that you had?
Yes, during the last visit I attended, the parents had been asked to hand over any materials they wanted to send home with the children, notes, letters, whatever, by their CPS worker. And they handed over the documents right away. It was just to ensure the content and safety of those materials. At the end of the visit, however, the CPS worker had cause to leave the immediate area. The family had asked her to obtain something from down the hall. And while she was away from the viewing room, I observed the mother take out another piece of paper, hand it to the oldest child, Ramon. He read it and set it on the couch in the room. And when Hortensia came back, the father kind of did a motion and swooped up that particular piece of paper, folded it quickly, and put it into the right pocket on Mateo's pants. And I saw that.
And did you confront the parents about that?
I did not. I advised Hortensia, the CPS worker, of the situation, and she took care of it. And she did obtain the piece of paper.
Did the parents acknowledge that they had handed over any letter to the children directly?
No.
Is there any specific concern as to, I guess, the parents handing over letters or anything like that to the children?
Yes, the children had received from the parents some materials to indicate what time or what date they would be returned home based on a court date that had been scheduled. And it caused a lot of distress to the children with their not understanding that was a court date that would only be a hearing date. And they thought they were coming home. And so we want to minimize the stress to the children and any confusion to be alleviated.
As part of your job as the CASA worker, have you visited with the children?
I have.
And did they indicate that when you talk about stressors, did they indicate to you about when they were going home?
They did not indicate to me a date when they were going home. It predated that note when I was visiting with them in the home. They just said they want to be going home soon, and they are going home soon.
Okay. And what kind of stressors were you concerned about? I'm sorry, may not have heard you.
It's an emotional distress on the children that I discussed with their placement provider, who expressed that the children were very upset, emotionally distraught over thinking they were going home on a certain date and learning they were not going home indeed on that date. That was just a court date.
As part of your job as a CASA volunteer, just in general with CASA, did CASA look into any placement options for the children?
Yes, we did.
What placement options did CASA look into?
We looked into the maternal grandmother who lives on the same property. And we also looked into an aunt. Kathy, I believe was her name.
What was the name?
I think it was Kathy.
Okay.
I might be mistaken.
And with CASA's efforts, is there anybody that was identified as a willing placement option?
No, not within the family.
Okay. Is there any other option that CASA is made aware of for possible placement of these children?
Their current placement with their foster parents is a good placement option for them, and the fosters are willing to keep them.
And you've been observing most of this hearing, is that right?
Yes, ma'am.
And did you hear or recall the testimony that was given about the father's request to have the children in their home with the mother out of the home?
Yes.
And does CASA have any thoughts on that potential option?
I do have a concern from the visitation with the family at the CPS office. I have noted on several of the visits that while the father he definitely takes the baby Mateo and holds him and plays with him. He's very engaged. When the baby cries, he does very quickly hand the baby Mateo over to his mother for whether she needs to, change a diaper or feed him or console him. While he does participate in diaper changes, he just seems to hand the baby over quickly, and not that he's been asked to, but here. And I'm just concerned, and I'd like to make sure that he's comfortable. If he were to be alone with the baby, what would happen when Mateo cries or needs tending to increase his comfort and confidence?
And do you recall the testimony about the potential for the mother in this case to go to, I forget the name, I think House of Refuge?
I don't know a name, but she has spoken to me about seeking inpatient or outpatient treatment over the past 6 weeks. She's mentioned it a few times, but to my understanding, she has not yet engaged into one of those placement opportunities or outpatient opportunities.
Are you familiar with the House of Refuge?
I personally am not, no.
Okay. In regards to the children, have you been out to their placement?
I have.
And do you believe that their needs are being met there?
I do.
Specifically, are you aware of the dental care that they have received while in their placement?
I understand they have had dental care. The very specifics I do not know, but it was generalized to me by their placement provider about the significant level of dental care and work that was required.
Right. And do you know if that's been tended to at this point?
Yes, it has.
Does CASA have a recommendation for the court in regards to whether or not the children should stay in the care of their foster home and under the care directly of CPS?
At this time, CASA does recommend that the children stay in their current placement and allow the parents to work services.
Okay. I pass the witness.
Mr. Maines? Mr. Maines, you're muted.
I'm sorry, Judge, and I had to correct myself, but I'll just start from scratch. I do have a couple of questions for her briefly.
Okay.
Ms. White, you mentioned the name of the aunt is possibly Kathy. Would the name of Kimberly ring a bell?
Yes, with a K. I did remember the K. I apologize.
Oh, no, that's fine. I just want to make sure when I suggest that name, does that now sound familiar to you, or is that coming just from me?
No, that does sound familiar.
And the indication from her as well is that she was not willing to take the children?
The indication is it's not an option for her at this time. Correct.
And to be specific, do you happen to recall if there was any discussion, or was she in position of not taking all three, or not taking one, or not taking anybody at a certain point?
It is my understanding that she had been interested in taking baby Mateo, but not the two older children, but that taking only baby Mateo is not an option at this time either.
No further questions, Your Honor.
Miss Watkins?
Hi, Angie. Just a few questions. Did you go out with Jenny Bratton to the home of the Segura family?
I did.
Okay. And so there wasn't any problem with the home physically itself, correct?
There were some minor repairs that are required, nothing significant, but there are some repairs that would be needed, yes.
Okay. So can you tell us what those were? Because when I spoke with Jenny, she didn't mention anything that would have been necessary.
Things like the floor inside the home. Some areas are uncarpeted, but obviously carpet's not an issue, but they were bare floors, and I would be concerned about nails or screws or other hardware coming through.
Okay, let me stop you there. So when you say bare floors, are you meaning dirt, concrete, or wood?
I'm sorry, wood.
Okay. And so did you personally observe any of these hazards that you are concerned about? Any
No, I
nails
did not
or
see
anything,
any.
but just in general, sometimes things like that can exist. Is that what you're saying?
Yes, from my experience personally, having bare floors during a remodel, I have experienced that that can be a concern and it should just be addressed.
Okay. Anything else?
As far as the home safety, no.
Yes. Okay. So the home was, I mean, in general, clean and, you know, acceptable for these children to live in, other than the issue that you just stated. Correct?
Yes,
Okay. Children had appropriate places to sleep and clothing, toys, that sort of thing, just normal for a family of that size, correct?
correct.
Okay. And did you find both Mr. and Mrs. Segura to be concerned and express an appropriate level of concern about the kids, asking about the kids and their situation?
Yes, they had appropriate level.
Okay. I'll pass the witness.
Mr. Green?
Yes, Your Honor. So you said you observed the visitations, right? Or some of them.
Yes, sir.
And it was clear from those visitations that Mr. Segura loved his children, right?
I can't speak to his emotional state. No,
Well, did he interact with the children in a loving way?
I believe so. Yes.
Okay. Wasn't so hard, was it? Did the children react to him in a loving way also?
The older boy, Ramon, absolutely. I was a little concerned about Journey being less engaged with her parents.
Okay. And then as far as the diaper changing thing goes, you're not saying that Mr. Segura couldn't change a diaper, are you?
No,
Okay. So he even if he wasn't doing it right then, he could easily learn how to change a diaper, right?
yes,
Okay. And wouldn't you say it's pretty normal when there's a mom and dad in the room and you got an infant that the dad, kind of defers to the mom a lot?
not in my personal experience.
You're not familiar with that, the idea of moms kind of, doting on infants? That's a new concept to you?
No, I've just had a lot of experience where fathers also being just as engaged with those types of duties.
Gotcha. Okay. So he looks like he could do it, but he deferred to the mom, but he was a loving dad at the same time, right?
Yes, sir.
Okay. And you said as far as the bare floors go, you didn't see any actual danger about those bare floors, right?
No, I did not inspect them that closely. No,
Okay. So that's just something you kind of thought might be a danger at some point in the future, but you hadn't seen any evidence of that, right?
correct. Potential hazard.
Okay. And as far as this note goes, you didn't read this note?
I did not.
Okay. I'll pass the witness.
Ms. Watkins? I'm sorry, Ms. Basnet.
I have no further questions, Your Honor.
Okay. Mr. Means?
No further questions of this witness, Judge.
Any other questions of this witness?
No, sir.
Okay.
Your Honor.
All right. Ms. Basnet, any other witnesses?
No, Your Honor.
Okay. Any other witnesses from any parties?
Yes, Judge. I
Okay.
would like to recall Hortensia Morales.
Okay.
Judge, I'm having computer issues. If we could hold on one second.
Sure.
Thank you.
While we're in this recess, Mr. Green, do you know how much time your pair hearing is going to take? And Mr. Crawford, what about your final hearing?
Your Honor, I would assume that pair hearing will only take a few moments. It's just a motion to enter an order and the court's already granted the divorce.
Okay.
So I would expect it to take a few minutes. Also, the Birdwell hearing, we have an agreement, so that should be a prove up. It shouldn't take
Okay.
very long either.
Okay. Mr. Crawford, what about you, sir?
Your Honor, it's just approval.
Okay. Why don't we do, as soon as Leslie gets ready, let's do those just so we can get some people out of the courtroom, and some might be here to be ready for a nap or something. So let's, Mr. Or the pair case, but I won't do it till Leslie tells me yay.
Okay. Okay.
I don't think that was Leslie's voice.
No, no.
The Russians have hacked into our computer. They've got our meat, they've got our oil, and now they've got our court reporter. Leslie, how much is the ransom?
I'm ready now. Thank you.
Okay. If it's over $10, I'm sorry, we're going to be stuck.
I understand.
Okay, this is the pair case. This is D20-29349-CV in the matter of the marriage of Jessica Ray Pear and Dennis Durrell Pear. I have counsel for the petitioner present, respondents present representing himself. Mr. Pear, is that you, sir, lying down?
Yes. Yes, that's me.
All right. This is a motion to enter. You may proceed, Mr. Green.
Your Honor, the final hearing on this case was held on March 18th of 2021. The parties did not have an agreement as to most of this, so the court ruled in open court. We proved up the divorce at that time, and I've just submitted a proposed order pursuant to the court's ruling attached to my motion. And if the court doesn't have a separate copy of it in the queue, I will submit one here in just a second. I'm not sure. Shonda's out right this second. I'm not sure if she submitted one before she left or not, but if she didn't, I'll do it right now.
Okay.
So I'm just asking the court to sign the order. That's all.
Mr. Pear, have you had an opportunity to review that proposed order?
Yes, I have, and I don't see where I need to pay her lawyer's fees or anything like that.
I don't have her paying my attorney's fees in there, Your Honor.
Okay, then I misunderstood that. What about the house? The house you're talking about reimbursing her 100% for all of her payments all the way back to December. I mean, wherever she lives, she's going to have to make payments.
That was my understanding of the court's ruling, Mr. Pear. So I was
Okay.
just trying to do what the court ruled.
Why did
Okay.
they, why was they gonna reimburse her? I paid for years there and nobody's reimbursing me.
Okay, Mr. Pear,
Thing happened to me is I got cancer and got kicked out and they're gonna, she
Mr.
gonna
Pear.
move in this other guy and I gotta pay for him to be there?
Mr. Pear, have you had an opportunity to review the order? I think you said yes. Do you have any objections to the order? I know you may have some objections to the ruling and disagreement, but as far as the order and how it comports with the court's ruling, do you have any objection?
I don't understand.
All right. Motion to enter is granted. That concludes this hearing. Mr. Perry, you're free to go.
Thank you, Your Honor.
Mr. Green, your client's free to go. Mr. Crawford,
Yes, Your Honor.
this is the Busby case.
Yes, Your Honor.
All right. We'll go on the record in cause number D21-29718-CV, interest of Cody Busby, a child. I have the petitioner present in the courtroom, represented by Michael Crawford. Respondent mother, Lynette Houston, according to the pleadings, is deceased. Respondent father, Rodney Busby, is deceased. Any other individuals, Mr. Crawford, that I need to note or have names called? I don't think so, but I just want to make sure.
John Moore is on, along with Michael Bryce Crawford.
Okay. All right. Who do you wish to have sworn? Mr. Moore?
Both of them.
Okay. Do y'all want to raise your right hands? Do each of you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, you may proceed.
Okay, John, I'm gonna call you first. Please state your full name for the record.
John Arden Moore.
And Mr. Moore, how do you know Cody Busby?
He is my younger brother.
And how old is Cody?
He's 13 years old.
And do you have a mother in common?
Yes, we share the same mother.
And what is her name?
Lynette Adele Houston.
And has she passed away recently
Yes, she passed away on March 23rd.
of 2021?
Yes.
And how long has Cody been living with you?
Since her cancer started about last January.
So has the child been with you for over 6 months?
Yes.
And you are, like I said, you are a biological brother to Cody, is that right?
Yes.
And you took care of Cody while your mother was ill and getting treatment for cancer, is that right?
Yes.
And was it your mother's wishes that Cody live with you?
Yes.
As far as Cody's father, had he already passed away prior to your mother passing away?
Yes, he passed away 4 years ago.
Okay. And do you have the financial ability in the home and the structure to care for Cody?
Yes.
And he's 13 years old, right?
Yes.
And it won't be any kind of a drag or a problem for you guys to take care of Cody and raise him.
No, we look forward to it.
And as far as Cody goes, has he made his wishes known to you?
Yes.
And what are his wishes?
That he would like to stay with us.
Okay. And are you presently married to Michael Bryce Crawford?
Yes.
And have you guys been a domiciliary of Texas for the last 6 months at least?
Yes.
And in the county you reside in for the last 90 days?
Yes.
Are there any other court orders out there as far as conservatorships, guardianships, or any other kind of orders that you know of that could affect Cody Moore and his ability to be named as basically y'all be named primary conservators of Cody?
No.
Do you know whether the child owns any property?
He does not.
And as far as medical coverage, are you guys going to be able to put him on medical insurance if he doesn't have benefits from the government on Medicaid?
Yes.
And are you and your husband presenting a final order, a parenting plan that you've had a chance to look at, asking the judge to sign?
Yes.
Do you think that the proposed parenting plan is in the best interest of Cody?
Yes.
And you're asking the court to approve it?
Yes.
Are you asking the court to award you and Michael Bryce Crawford as a married couple custody of the minor child, Cody Moore,
Yes, sir.
and to approve the order?
Yeah.
Pass the witness.
I call your next witness.
Call Michael Bryce Crawford. Please state your name for the record.
And I swore both. Yeah, I swore both of them. Thank you. You may proceed.
Please state your full name for the record.
Michael Bryce Crawford.
And you spell Bryce B-R-Y-C-E.
Yes, sir.
And you're currently married to John Moore.
Yes.
And do you agree with all the questions that I asked John? Would you have the same answers as John had?
Yes.
Are you asking the court to approve you and John Moore as the conservators of the child, Cody Busby?
Yes.
I'll pass the witness, Judge.
Okay. Any other witnesses?
No, Judge, and this will be a final order.
Okay. Based on the testimony that's been admitted, I'll find that the relief that's being requested is in the best interest of the child, Cody Busby. And I think there's an order in the queue, so I'll sign it here momentarily.
Thank you, Judge.
All right, that concludes this hearing. Good luck to both of y'all.
Thank you.
Thank you.
Thanks, Your Honor.
May I be excused, Judge?
Yes, sir.
Thank you.
Mr. Green, do you want to do your 130 prove-up that you say is agreed to before we get back into the?
I would prefer to if we could, Your Honor.
Okay. Just trying to get as much out before we, all right. Birdwell. Okay, Mr. Green, your client is here.
Yes, Your Honor, that's him. It says DJ's phone over there.
DJ's phone. Okay, and then the respondent is present. Is that D'Amica Birdwell?
Yes, Your Honor.
And ma'am, let me ask you this. Do you have an attorney?
No.
Okay, but Mr. Green, you said that you and Ms. Birdwell, well, your client and Ms. Birdwell have worked out an agreement. Is that correct for temporary orders?
Actually, Your Honor, I believe it's going to be a final agreement.
Oh, okay.
Even though we were set for temporary today, I believe they've reached a final agreement.
Okay. All right. And Ms. Birdwell, is that correct?
Yes, sir.
Okay. All right, then we'll go on the record in D15 24398-CV. And this is in the interest of the children, Dylan Birdwell, Daya Birdwell, Davis Birdwell, and Dixie Birdwell, children. I have the petitioner is in the courtroom represented by Neil Green. The respondent's present. She is representing herself. This was set for temporary orders. My understanding is the parties have reached an agreement as to make this a final order. Is that correct?
Yes, Your Honor.
Okay. And so do you want to call your client and Ms. Birdwell?
Yes, Your Honor.
If y'all can both raise your right hands.
I noticed Mr. Birdwell is muted, Your Honor.
Okay. Where it says yes.
There
right.
is.
If y'all can raise your right hands, do each of you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
You may proceed.
All right, Your Honor, I'm going to call DJ Birdwell.
Okay.
Are you DJ Birdwell, aka Donald Joseph Birdwell Jr.?
Yes, sir.
And Mr. Birdwell, you're the petitioner in this case, correct?
Yes, sir.
And Miss Birdwell, D'Amica, is the respondent, correct?
Yes, sir.
And y'all have 4 children: Dylan Andrew, Daya Noel, Davis Brandon, and Dixie. And what's Dixie's middle name?
Lee.
Dixie Lee Birdwell, correct? And I'm just going to ask Mr. Birdwell first, and I'll come back to you, Miss Birdwell. Okay?
Oh, sorry.
That's all right. We'll keep the record clean this way. So, Mr. Birdwell, we petitioned to make certain modifications to the final decree of divorce that was done in this case, correct?
Yes, sir.
And you and Ms. Birdwell, mostly without my involvement, have come to an agreement, correct?
Yes, sir.
All right, and that agreement is that as to Daya and Davis, and I guess Dylan too, although he's pretty old, so it's not going to matter quite as much. But as to Daya, Davis, and Dylan, y'all will be joint managing conservators, but you'll be the party who has the exclusive right to designate the primary residence of the children and make educational decisions. Is that correct?
Yes, sir.
And then as to Dixie, you're going to leave the rights and duties the way they are right now in the final decree of divorce, correct?
Yes, sir.
And then as to the visitation schedule with regard to Daya and Davis, Ms. Birdwell is going to have standard possession without elections, meaning weekend possession, except for y'all are going to guarantee that she has 2 weekends instead of the normal first, third, and fifth. She's going to have 2 weekends a month, and she's to give you 30 days notice of what weekends those will be. Is that correct?
Yes, sir.
And then as to Dixie, that visitation schedule is to stay the way it is in the current orders, correct?
Yes, sir.
Okay, and then Miss Birdwell has agreed, and this is part of your agreement, that she's going to take drug counseling from somebody that y'all agree to, correct? Or just
Yes, sir.
just on her own, she's going to take drug counseling, and she's going to provide you with proof that she's done that, correct?
Yes, sir.
And then she's also going to take a parenting class as well, correct?
Yes, sir.
And provide you with proof that she's done that as well, correct?
Yes, sir.
And nobody's going to pay anybody child support, and the health insurance provisions are going to remain the way they are right now, which is that you provide health insurance for the children, and that all uninsured costs are split between the two of y'all evenly, correct?
Yes, sir.
All right, now that's your agreement that you've reached, right?
Yes, sir.
And you believe this agreement's in the best interest of the children, correct?
I do.
And your right to designate the primary residence of Daya and Davis and Dylan is without regard to geographic restriction, because you actually live in a different county, correct?
Yes, sir.
All right. I'll pass the witness, Your Honor.
Ms. Birdwell, do you have any questions to this witness?
No.
Okay.
Now I'll call Tamika Birdwell, Your Honor.
Okay.
Ms. Birdwell, did you hear the agreement that I just read into the record?
Yes.
And was that the agreement that you and Mr. Birdwell have reached?
Yes, sir.
Okay. Now, you know that we were noticed today for this to be a temporary orders hearing, correct?
Yes.
And we've now reached an agreement that we would like to go ahead and enter a final order and have this become the final hearing, correct?
Yes, that's correct.
And and obviously I'm not your lawyer, but you know that you have the right, there's certain notice provisions. In other words, you get at least 45 days notice of a final hearing. You know, you have the right to go out and hire your own lawyer. In other words, you could put this off and make this into a temporary orders hearing if you wanted to. You understand that?
Yes, I understand that.
But knowing all that, you decided to go ahead and make this into a final, correct?
Yes, sir.
And you believe this is in the best interest of your children?
Yes, sir.
All right, I'll pass the witness, Your Honor. And Your Honor, I'd like to recall DJ very quickly.
Okay.
Mr. Birdwell, I neglected to ask you something a minute ago. You heard the questions I asked Mrs. Birdwell regarding the fact that we were noticed for a temporary hearing. That's what we were planning to come to. And y'all have reached a final agreement, correct?
Yes, sir.
And just like I said to her, you know that we have the right to 45 days notice and, you know, discovery, and there's all kinds of things we could do between now and a final hearing. But you've decided you want to forego all that, just make this into a final, and this be the end of it, correct?
Yes, sir.
Okay. I'll pass the witness, Your Honor.
All right. And Ms. Birdwell, again, do you, as far as this line of testimony, any questions?
Not at this time.
Okay. All right. Anything further from either side?
No, sir.
No, sir.
No, Your Honor.
Based on the testimony that's been received, the parties appear to have agreed to all terms and conditions to make this not only, they've agreed to the terms and also agreed to make this final, waiving the notice provisions. So the court will find the relief that's been requested is in the best interest of the children, and I'll sign an order when it's presented. I believe that concludes this hearing.
Thank you, Your Honor.
Okay, thank you.
Give me
Thank
1
y'all.
second. I'll be right back to the other case.
Okay. And DJ, you can exit.
10-4.
Okay, Leslie, the 2 o'clock is off. Leslie, did you hear me?
Sorry, I was on mute. Yes, thank you.
Oh, that's okay. The 2 o'clock has been taken off, so.
Thank you.
Okay, we'll go back then to make sure we got everybody. Okay, we're back on the record, and Mr. Means, you may call your next witness or your rebuttal.
Yes, Your Honor, I would recall Hortensia Morales.
Okay. Ma'am,
Yes,
you're still under oath from yesterday.
Okay, Your Honor.
You may proceed.
Thank you, Your Honor. Ms. Morales, are you familiar with the dental work that was, first of all, has there been any dental work performed for the children since they've been in foster care?
Yes.
And do you know what that work was?
Yes, I do.
With respect to, let me ask you one at a time. With respect to Ramon, what sort of dental work has he had?
He has had 3 extractions, and he is waiting on some spacers. The extractions were due because he had infections under some of the crowns on, or actually under 2 crowns. So he was given amoxicillin for that. And that's all that's been done so far.
And was that all done at one time?
Yes.
And was that, did that involve a surgery and anesthesia?
Yes.
With respect to Journey, has she had any dental work done? And if so, what was it?
She has. She had 5 cavities, which due to those cavities, the severity of those cavities, she had to have 2 mini root canals.
Were those also done all in one day?
Yes.
And actually, were both of the surgeries on each of the children done on the same day?
Yes, they were.
And was Journey's surgery also anesthesia?
Yes.
And with respect to the general health of the children, at the time of the removal of the children, and I'm talking about the adult children from the grandmother's home, is that where they were removed from first?
Yes.
And at the time that, and did you do that removal? Were you there in the home?
Yes, I was.
And at the time of that removal, did you notice anything about the Journey's behavior or anything about her health at that point?
I noticed she was coughing a lot, and I had to ask Miss Runyon, the grandmother, what was wrong with her because she was just coughing extensively, like a lot.
And what were you told about her condition or why she was coughing?
I was told that she had
Exit hearsay, Your Honor.
I'll sustain.
Now, from that day, Journey's been placed in foster care. Is that right?
Yes.
Has she been in the same homes since when she was first placed?
Yes.
And how's her health right now with respect to her coughing?
She is no longer coughing.
Was she using an inhaler at the time that you picked her up from the grandparents' home?
Yes.
Does she use an inhaler now?
No.
Has she had any coughing and any breathing problems at all since she's been in the foster home?
No.
Now, were you involved directly in placing the children, taking the children to the foster home?
Yes.
And how did they react when they were taken to the foster home?
They were excited.
Did they have any express any disappointment or concerns or any sort of sadness at all of being taken to the foster home?
No.
And did you hear the testimony earlier in the case about the from Mr. Segura talking about checking into rehab for Jamie?
Yes, I did.
And do you know where they got the information about how to find rehab and where to go?
I provided Ms. Ray with some resources, phone numbers she could call and do research on where to find rehab centers.
Now, the child, I'm sorry, the two adult children, they were removed on a Friday, April the 16th. Is that right?
Yes.
And when did you first talk face to face to the parents?
That was April 19th.
Would that be the Monday following that Friday?
Yes, sir.
And at that time, did you talk to them anything about rehab at that point?
Yes, I did.
Was that when you gave her the information or was there just a conversation on the 19th? What happened?
So when I was talking to her about the substance abuse, she acknowledged that she does have an addiction problem to meth. I asked her if she felt she would benefit from doing any type of rehab. And she told me that she would, that she that's what she wanted. So I told her that I was going to look up some information to where she can contact and get information for whether it be inpatient or outpatient treatments. And I provided that to her on Wednesday of that week, which would have been April 21st.
During your conversation on the 19th, was there any indication that she had made any efforts to seek rehab before that day, before you
No.
gave her the information?
No.
I'll pass the witness.
Ms. Watkins?
I don't have any questions of this witness.
Okay. Mr. Green?
Me neither, Your Honor.
All right. Ms. Basnet?
Just briefly, Judge. Ms. Morales, I wanted to clarify something. You had testified that both children had to be put under anesthesia. Is that correct?
Yes.
Was the plan not to have them put under like funny juice or something before the anesthesia?
Funny juice.
Or like
I guess I'm confusing the funny juice with anesthesia. Because I know that they weren't allergic to anything, which that was a question asked by me or to me before the procedure, and I had asked the parents. But yes, that is correct.
Okay, so they just gave them, I guess, nitrous oxide or something along those lines to keep them calm and sedated, not necessarily putting them full on under.
Right.
Okay, all right. Just wanted to clarify that. Thank you. I pass the witness.
Mr. Means, any other questions?
No further questions, Your Honor.
Any from Ms. Watkins or Mr. Green?
No, Your Honor.
No, Your Honor.
Okay, Mr. Means, any other witnesses?
Your Honor, the only thing I would do, I would reoffer petitioners C. I have it on screen to share. The only issue is it's mismarked as Exhibit A on the screen share. This was offered earlier in the case, and I believe it was objected to at the time or delayed. I don't believe it's been admitted yet, so I'm reoffering it now.
If it wasn't admissible before, I would assume it's still not admissible, Your Honor.
Well, do we want to screen share it, Judge?
You can put it up. I'm not going to look at it though until.
Sure.
I'm not sure what we're talking. The one that was the objection was sustained yesterday. That was on.
This is, Your Honor, the objections that were sustained were the two exhibits, two drug tests that were argued about. This is separate from that. This is not a drug test. This is strictly an affidavit identified as a related to the hospital.
Right, because I think the court carried that objection. Isn't that right, Mr. Means?
I believe that's correct. That's why I'm reoffering it now. And I would correct that it's showing up on the screen as Exhibit A. But first of all, can everyone see it? I'll move it, but
for some reason I can't see it. I don't know why.
Well, I've got it shared on my screen. I think that's all I know to do. Let me see.
Can anybody else see it?
Nobody's seeing it.
I'm sorry. Now I just click share. There it is. Now is it visible?
Yes.
All right. And there's the top, and then I'll scroll down to the bottom briefly, and then I'll go back up to the top so you can read it. And it's mismarked Exhibit A. And I believe this was sent to council before the last hearing.
And tell me what it is again without telling me what it says.
Yes, Your Honor. This is an affidavit from a witness from the hospital. It is not a test report of any kind. It's strictly the testimony of this witness in affidavit form, and it's being offered rather than her live testimony pursuant to the Supreme Court's orders.
Okay. Yeah, I do. I was getting it mixed up with the drug test exhibits yesterday. I guess, is it the same? I did carry that. Same arguments from counsel?
Yes, Your Honor. I think Ms. Watkins and I made due process objections, hearsay objections, and lack of proper business records, authentication, and admissibility objections, and hearsay within hearsay objections, if I remember correctly, and I would reiterate.
Okay.
Your Honor, I would, if I could just briefly respond with respect to the hearsay within hearsay. The hearsay that's in the statement is the witness talking to the mother, the party in this case, and so I would suggest that's not hearsay from the party. And then with respect to the witness, this is not a business record either. This is strictly a witness affidavit pursuant to the Supreme Court's order.
Objections overruled. C is admitted. Anything further?
No, Your Honor, not for me. And I would just clarify the court that the exhibit that I've displayed is marked as Exhibit A, and I will correct that for the reporter. And that's what the court has just introduced or admitted as Exhibit C. The earlier exhibits that the court denied were Exhibit A and Exhibit B. And so I just want to clarify that on the record, and I'll provide the properly marked exhibit to the court reporter.
Thank you.
And I rest.
Okay. Anything further other than closing?
No, Your Honor.
No,
No,
Your
Your
Honor.
Honor.
All right, I'll take closing.
Petitioner first, Judge.
Yes, sir.
Your Honor, I would simply ask for the court to grant a TMC to the department as we have sought. I believe the evidence is first of all, is clear of my mother's use of methamphetamine. And as the last witness just clarified that the mother admitted that she's addicted to the drug. We've offered extensive evidence about the history of this family. And the focus on the 2018 largely was to demonstrate the issue of the appropriate placements that are available to the court other than foster care. And so far that's been offered as the grandmother, as an aunt, and as the father. And I believe the testimony was for both of the aunt and the grandmother, that although there was some initial discussion about the aunt only taking one child and the grandmother, whether or not she wanted all three or just two. And I think that was resolved finally clearly for the court, a lot of back and forth, but it finally determined that neither one of those placements, the aunt or the grandmother, was willing to take anyone at this point, even if it was down to just two. The two older children, the grandmother finally said she wasn't willing to do that as well. And I think that was clear because the witness finally clarified that at the point that she was talking to the grandmother the last time, the grandmother was fully aware that they were only talking about the two kids at that point, because the aunt at that point was considering the infant at that time. And then finally, both of them backed out on everything. With respect to the father, our concern about his placement is the history of the father's concern. First of all, he testified today that he doesn't see that the mother presents any danger to the child, even with the knowledge of her methamphetamine use. And he's represented that he's generally ignorant about that and doesn't know that she uses meth. And yet it's clear that she's left alone with the children at a point, and he certainly has a history with the mother, knowing that she used meth in the past. And he's indicated that he became aware of it and even took action to try to stop the supply to her. And so we're concerned, but basically we do not think that he is in a position to be protective. I think the argument is that he's simply not taking this seriously and hasn't in the past. And I would point to the 2018 case. That's not just ancient history, but the issue of that is what it shows about the father's behavior. And the point at that time was that the grandmother had been with the mother and the children all day the day before, and observed the mother acting erratically and mentally unstable, for lack of a better word. And that, as Ms. Heiserman testified to, the grandmother told her that all she did was to send the kids home and didn't tell the father anything about what she'd observed that day. I think she said that she just assumed he would recognize that she was unstable. And then the father is acknowledged today that he recognized the mother had problems that night. And he told Candace that the caseworker, that he recognized the next morning that she still had problems. And the only thing he did was tell her to take the kids to school. And then he takes off to work. And the next thing anybody knows, whether the grandmother or the father, that are now being been suggested as possible placements for the children, is the next thing anybody knows, his mother's walking down a country road with both of them in tow, dodging traffic. And that led to law enforcement and the sheriff's office being called and led to the removals that occurred there. And then obviously the department worked with him at that time and worked them to the point of working services, and the children were ultimately returned. But the issue is the pattern of behavior and the extent to which anybody takes the mother's condition seriously and the relation to the protection of the children. And that's why we recommend to the court that the current placement is in the children's best interest. The father has, as the court heard the testimony, that the father was even tested since this case began. And the caseworker testified that they had him tested, and then after he was tested, she had concerns for him not just using marijuana, but had concerns about him using meth and cocaine. And as the father has indicated, that yes, he's willing to do anything the court orders at this point, but before that, he had no plans, and he hasn't done anything about that with respect to the mother's meth use, There's no evidence of him doing anything about respect to the mother's mental condition, whether or not that continues or whether or not it's strictly meth at this point. And that he's now willing to do whatever the court orders, anything to do to get the children back. But there was no plans of that before now. And that's the whole point that we have, the history of this case, that nothing happens until CPS gets involved. That's happened in 2014 with meth use, and then the kids were placed back at home. And then it turns out that both parents used meth and cocaine after that. And that led to the kids being removed again. And then the department worked with them and they worked services and ultimately determined that they had demonstrated enough and the children were returned. And then we go to 2018, we have that repeat. And now this is 2021 and we're back again. And we're suggesting that the safest place for these children until the parents can complete services and work with the department again and maybe get the help Miss Ray needs that she says she's willing to do. But again, they hadn't sought anything of that before CPS gets involved now. Our suggestion is, and our concern is that the children need to remain safe in foster care, and then the department can work with them and see what they can do in terms of creating a safe environment and moving forward. And I think that's CASA's recommendation as well. And that's what we asked for.
All right, Ms. Watkins.
Thank you, Your Honor. There's been a lot of talk about history in this case, but I would like to remind the court that the statute requires immediate danger at the time of removal. And I would suggest to the court that immediate danger at the time of removal has not been shown. In fact, the caseworker, Ms. Morales, testified that the kids, older kids, were not in immediate danger at the time of their removal. They were in the home of their grandmother, and she testified at that time they were not in immediate danger. They were not in danger. As such, reasonable efforts were not made to avoid removal, which is another requirement of the statute. A safety plan could have been put in place, and the older kids left in the care of Ms. Runyon, who indicated at that time, according to the testimony of Ms. Morales, that she would keep the kids, but that option, and wanted, in fact, to keep those children, but that option was not explored. It was not given to either the Seguras or Ms. Runyon. And the only reason given for that was the history of Ms. Runyon in what the department characterizes as not being protective enough in the 2018 case. I would point out to the court that the court in that case in 2018 heard that exact evidence, and whether that the court did not believe that testimony or did not find that testimony compelling, the court at that time placed these kids with Ms. Runyon, and the family worked services, and the children were returned back to them. And so I would indicate to the court and argue that the statutory requirements for removal have not been met in this case, because those requirements were required to exist at the time of the removal. But also point out to the court that the concerns that the department had and has testified with regard to Mr. Segura's drug use were also not known to the department at the time of the immediate removal, but only discovered thereafter. Ms. Segura is a good mom, and she realizes that she needs to be her full self and clean to continue to be a good mom to these kids. And so she wants to seek out and is willing to seek out rehab. I know that it's been a little bit of time since the kids were removed, but we are just now having the full adversary hearing. So we are kind of in a different position than we normally are. And I think it's reasonable for Ms. Segura to wait to absence herself from their lives and all the proceedings that go on until we get a ruling from the court so that, she can then start to focus on getting better. And they have made efforts, both of them, to seek out and find a program that she can go into. And I commend her for that. I know that there's been some testimony with regard to Mr. Segura's ability to care for these kids. Mr. Segura has been a dad to these kids for the older kids for several years now. And I think that it is understandable that he would maintain a traditional role of a dad and kind of deferring to Jamie in the day-to-day care of these kids, but there's not been any evidence that he isn't perfectly capable of stepping up to the plate and doing that at this time when it's necessary to help out his kids. I think testimony's been these kids want to go home, and that they are being negatively impacted by being away from their family and being away from their parents and being away from their grandmother, being away from their home. And I find it completely disingenuous and utterly ridiculous, Hortensia Morales' testimony to suggest to the court that these kids didn't care at all about being removed. I think that kind of goes to the credibility of that witness. And so we would ask, Your Honor, that the department's petition be denied, that the children be restored back to Mr. Segura with the condition that Ms. Segura check into rehab and not remain in the home during a certain amount of time, and that they be ordered to complete family-based services until the department is satisfied that they can get out of the case completely. Thank you, Your Honor.
Mr. Green?
Yes, Your Honor. Mostly I want to reiterate what Ms. Watkins just said, but I point the court to Texas Family Code Section 262.201, which governs full adversary hearings, which I believe is the statute governing this hearing. And as Ms. Watkins said, there's several things that need to be present. One, there has to be a danger to the physical health or safety of the child. Well, we can argue about the baby, obviously, but the other two children, I don't think anybody has demonstrated at all that there was a danger to the physical health or safety of the older two children. And I meant to start by saying the default is that the court returns the children. In other words, if you read that statute, it says that in a suit, the court shall order the return of the child to the parent unless the court finds sufficient evidence to satisfy a person of ordinary prudence and caution that, and then it lists this. So the default is the court returns the kids if they can't prove this stuff. So they got to show a danger to the physical health or safety of the child, which I think they failed to do regarding the older two children at least. Then they've got to show the urgent need for protection required the immediate removal of the child. Well, again, these two older children weren't at the hospital. They weren't in some sort of immediate danger. They were fine. And I don't think they can show the second part. There's no evidence that there was an urgent need for protection of the and removal of those children. But then moreover, Your Honor, they've got to show that reasonable efforts have been made to enable the child to return home. I think CPS has utterly failed at that. I think Ms. Morales testified that this decision was made before there was any evidence and before they made any kind of reasonable efforts. So nobody has complained about the condition of the home. All the testimony by everybody has been that my client, Mr. Segura, is engaged with his children, that they love him, that he loves them. And they haven't made reasonable efforts. They haven't tried to work with him. They haven't given him a service plan. They haven't done all the things that they're supposed to do to make the reasonable efforts. They just decided on their own that, this guy's no good. He can't take care of the kids, and therefore we're not going to give these kids back. But the way it was working before was Bobby was there, and he was there with the children. His wife was the primary. He helped, and Ms. Runyon helped. Well, now he's going to have to step up. Not shown anything to show that he's not going to step up. I mean, regardless of what Miss White said, pretty normal for a dad to hand the kid to the baby to the mom to change the diaper. And so, that's just kind of silly. I mean, he can step up to the plate. He's obviously very engaged and willing to do so. So I don't think that they've proved their burden here, Your Honor, at least with regard to the older two children. So I'd ask that the court immediately return those kids, deny this petition.
Ms. Bassett?
Judge, can everybody hear me okay before I start?
Yes, ma'am.
Your Honor, I want to make sure that it's abundantly clear to this court, because part of my duty is to ensure that the children are heard in this case. And like so many other children, these older two children made it abundantly clear to me that they want to go home. So part of my job is to inform the court that, and I want the parents to understand that as well, that their children want to be with their parents. The concern comes down to, is it a safe and appropriate place? Because as we know, these children deserve safe, stable, and sober parents. They deserve to be in that home, and they deserve to stay in that home. These children, through the history that's been testified, have gone back and forth several times, and that doesn't go up without trauma to these children for having to go in and out of their parents' home. So it's important to understand some of the history here, but also to understand the risk and danger that could potentially be posed to these children. We have Mateo, who was exposed in utero to meth by his mother's use. And we have the older two children who have, by the testimony, shown that they've been exposed to at least parents under the influence of meth. The father testified that he cared for these children while under the influence of meth. The mother has, the father's testimony in regards to the mother is that she is the primary caretaker of these children, and she has been using meth since she's been pregnant. So the concern comes down to, what exposure or danger does this pose to the children? And I do think both the parents need to be educated on what that does to these children, not only just the simple fact that CPS can be in and out of their lives, but medically, psychologically, what kind of exposure happens to children and what it does to children when they're exposed to these drugs. I believe that the mother does need to be in care. She does need to treat her addiction that she has, because you cannot be a good, stable, safe parent while using drugs or not attending to your needs to be a sober parent. I believe, based on the father's testimony, that he also needs to have extensive classes, as well as he needs to come up with his own sobriety plan. He has testified to his drug history of being methamphetamines, cocaine, and marijuana. But I didn't hear any testimony about any NAAA classes that he's tried to do on his own to work his sobriety plan to ensure that he has continuing sobriety for these children. And I would hope that there is a plan that they can have in place so that they do have long-standing sobriety, so these children can remain with them, because ultimately that's what they want to do. I also believe that he needs to work on being able to identify and be present to determine what signs of drug use there are in the home for any future issues, so that he can be proactive and this situation doesn't ever happen again. I did visit the foster home. I do know that these children have their needs met. They are in a safe and appropriate home. They are well cared for. So I want the parents to understand that regardless, they are being well taken care of, and I am watching over that. I know that there is going to be an issue for the court as to whether or not the burden has been met based on the testimony itself. I have great concern for the plans for these children if they are returned to the home, only because I want to ensure that, again, it is to a home where they are safe, stable, and sober. And I believe there may be some more work to be done. And I believe that regardless of the court's ruling, that the drug use in this family has to be addressed, because it is inappropriate and unfair to these children to have parents who are using and continue to use. So as far as my recommendation, I do believe that there's a concern for safety for the return of the children. However, I am going to defer any further recommendation as to whether or not the department has fully met the burden.
All right. Mr. Means, you have the final say. Anything further?
Yes, Your Honor, I do. With respect to the question of the immediate danger that the children were in at the time of removal, very simply, the immediate danger presenting to all of the children was the prospect of remaining in the continued care of the meth user, the mother. The evidence before the court was that the two older children were basically temporarily being overseen or babysat by the grandmother while the parents were at the hospital with the birth of Mateo. And there was no indication that was going to continue or any sort of permanency to it. And the immediate danger would be the prospect of the fact that immediately upon the parents' discharge from the hospital or the mother's discharge from the hospital, that's where all the children were going to go. That's what the mother said at the hospital and in the affidavit to the social worker. And that's the immediate danger that we're looking at is where were these children going to go and where were they going to remain? The question for immediate danger is not simply a question of at this precise moment in time, were the children safe and was there no immediate threats hanging over their head at that precise moment? The question is facing the department is the continuing danger to the children. And I'm not trying to rewrite the statute, but I'm pointing out that that was an immediate danger facing the department and facing these children because that's where they were going to be immediately or just as soon as physically possible. And I think the department is not required to wait and sit back and then see how that goes or to leave the children there and be placed in that risk before the department is allowed to act. And the basis for the department's immediate action was based upon that serious threat to the children that existed at that moment. And that affected not only the infant who was already affected, but affected the older children who the evidence now has established that they had been in their care up to that point, that the department knew that the drug history in the home from the extensive history of the mother and the father's involvement before that. And now the only issue is that that's now been confirmed since the removal. It's been reemphasized and reaffirmed since the removal. And so that establishes the immediate dangers is my argument to the court. And it's not just my argument, but I think that's what the evidence shows. And with respect to the question of reasonable efforts, the department clearly looked at the options that they had available to avoid removing the children. And the options were to leave the children with the grandmother. And the evidence before the court, as I've just said, was that those children would be necessarily immediately returned to the parents, the meth user, as soon as she got home. And that the department was fully entitled at that point to consider the viability and the safety of the children remaining in any one of those parents' care. And the evidence that the department had before it, and they're fairly entitled to consider their reasonable efforts considers what options they had at that point. The options were to leave the child with the grandmother, where they already had evidence that they knew that the grandmother had not been protected before, regardless of what some other court thought about it. That's the evidence and the information that the department had before it. And there's been no challenge to the truth of that, other than the fact that maybe the court didn't agree with it or didn't see the extent of the threat. But there's been no evidence to contradict those facts and that's what the grandmother told the caseworker. There was no challenge or dispute about that. And that's what the father told the caseworker. And I would submit that with respect to reasonable efforts, that's a part of the efforts that the department did, that they engaged in, and they're entitled to do. And they did not have any reasonable placement for the children at that time, other than the father, other than the grandmother. And they had all that information before them as to what threat that presented to the children in terms of leaving the children there. And I would submit that they exhausted their reasonable efforts at that point and that the removal at that time was proper with the statute. And I would simply argue lastly that this is the first time I've ever heard it argued that it's a good thing for a father to limit his engagement and to just be casually involved or just there and defer everything to the mother. I can't believe that we're arguing about that as being a reasonable situation. And I think that just goes to the long-term issues of where these children need to be while the parents do all the work that the evidence clearly establishes that they need. And the department has been down this road before with these parents, and the evidence is clear the department is prepared to do that. And also with respect to the mother entering rehab, there's been no evidence yet to establish that she is going into rehab, has established anything for rehab. All that we've heard so far is that the department has given her information about where to do it, and the father said that they're looking into it. Beyond that, there's no other evidence before the court to document that anything is going to happen yet. And our concern there is that, as the fathers testified, that they're all willing to do it going forward, but we wouldn't be here if anybody had done any of that before now. And these children are in danger because of that lack of action. And that's why we recommend that the department have TMC, that they remain in their current placement while the department continues to work with these parents in the normal course of business with this court overseeing it and the ad litem, et cetera, and make every effort to try to reunify this family. But right now, it's not appropriate from our position to return the children to that family.
I will be in recess, and I will be back at 3 o'clock to issue a ruling. So y'all hang tight.
And Your Honor, I have a probate hearing at 3:30, just FYI.
Okay.
Yeah, should be fine.
All right. Thank y'all. Okay, do we have everybody here?
I don't see Mr. Green.
Guess it would help if I turn my volume up. I know there was a 2 o'clock hearing, and that is my understanding, it was taken off for lack of service. I think service had not been perfected. Is that correct?
That's correct, Your Honor.
Okay.
He's on the run. Another warrant has been issued for his arrest. So
Okay.
if it pleases the court to extend the TRO, and we'll get another order to Ms. Butler.
Yeah, just to get that to me and I'll sign it.
Yes, Your Honor. Thank you. I don't see Mr. Green.
I sent him a message, so I'm hopeful that he'll be on in just a moment.
Okay, we'll come out of recess and we have parties present, council's present, and I'll just make some comments and then to the ruling. And it seems like the scourge of drug use continues to cripple our community like it does a lot of communities, and tearing up families, parents, and ultimately the children of these families. Some of the evidence that came out that, is troublesome. The decision to use methamphetamine while pregnant is basically unconscionable. The potential damage that's done to the unborn child is either hopefully temporary, but hopefully not permanent. It's not deserving of a newborn. The children in the presence of parents under the influence of illegal drugs causes unintended consequences. The accidental ingestion of those drugs, being the victim of a drug-related psychotic event that can sometimes occur, an encounter with a drug dealer that cares only about one thing, making money. Concerns that we all should have about the children. I'm hopeful, and I'm always hopeful for things to get better, no matter what the situation. I hope that the mother will get the help that she needs now, not tomorrow, but today. I'm hopeful that the father will get the help he needs today. Make that decision today to start making some changes, so the department's not in your life, in your lives, or your children's lives in the future. I will make a finding at this time that the department should be named temporary managing conservator of the children. The parents are named possessory. I'll find that the parents are ordered to review the service plan that will be prepared at this time and are in the near future and submitted to those parents for review. I'll order the parents submit to a hair follicle in the next 24 hours so we know where we are as of today. I didn't hear anything about child support, so I guess I'll leave that alone at this time for a future hearing. But I didn't hear the request, unless the request was made and I didn't hear it. Was that request made?
No, Your Honor.
Okay. I want visitation to continue as has previously been scheduled. This is all on the parents. I understand that they're probably not happy about this court's ruling, but this court's ruling is done not to punish, not to discourage, not to be a judgment call on you as individuals. It's simply to make some efforts to make sure that you're not using illegal drugs, you're not doing things that harm your children, that you are doing things to make sure your children are cared for, and that hopefully those 3 children of yours can be back in your custody sooner rather than later. I will give you your admonishment that, is Mr. Segura still in the courtroom? I will admonish both of y'all that unless you're able to provide your children with a safe and/or stable environment, your parental rights and/or duties may be subject to restriction and/or to termination. And I don't think we're going to get there, and I hope we don't. I have all the confidence that y'all will redirect where you are today to do something positive for yourselves and ultimately your children. Is there anything I'm missing?
Judge, with respect, the court has ordered an immediate drug test. If the court wants to order this time or wait until a status hearing for service plan recommendations regarding any ongoing drug testing.
Maybe so. I want a hair follicle within 24 hours. So that way we know where we are today. And those hair follicles may help develop a better service plan.
Nothing further from us, Judge.
This is not to take away from the mother's desire, from what I understand, to enter into a rehab. If that does occur, she has all the approval of this court to do that, which I know would limit some of the service plans that could be ordered. But I think from what I've heard, it sounds like this is something she's wanting to do. And it sounds like that would be a good course of action to take at this time. But short of that, I'll sign an order when it's presented. And obviously with this court's ruling, the court has made those findings that there is a danger to the physical health or safety of the children. And at this time, it's contrary for them to remain in the home. There was an urgent need for immediate removal, and that there's a substantial risk of continuing danger to the children at this time if they were to be returned. I will sign an order when it's presented.
So just for practical purposes, Erica, will you be getting in touch with mom and dad to facilitate that hair follicle test?
They can go now. The 2054 is being done.
Okay, so that would be to NAVCO?
Yes.
Okay.
All right. Anything further?
No,
Nothing
Your
from us.
All
No,
right.
Your Honor.
Yes,
No, Your
Judge.
Honor.
That concludes this hearing. Thank you.
Thank you, Your Honor.